Hi, my name is Jake Szulinski, and this is Investing Sense. What we like to do on this show is help our viewers educate and learn more about financial topics. And our financial topic that we're going to be talking about today is estate planning. And with me, I have Laura Tobey from Tobey Law Offices. Hi, Laura. Thanks for joining us today.
How are you?
I'm doing well. So we're going to be talking about estate planning today, which I know I've worked with you in the past, and you do a lot with.
Yes, absolutely.
Well, good. Well, tell me about your practice and how you got started in law and estate planning.
Sure. I graduated in 2003 from Dickinson Law, and then I clerked for a judge. And thereafter, I went into private practice. So I've been in private practice for about 15 years.
Okay.
And in 2012, I moved my practice back to the main line because I grew up here and I wanted to raise my kids here.
That's great. And you've been here ever since, practicing law. That's great. Well, I know from the clients that I work with, there's a few documents that we probably would say are a necessity. And me and you have talked about this before, maybe the top 3 documents that if somebody wanted to get started on an estate plan, and I want to talk a little bit about those today.
Sure.
So what are those 3 documents, first of all, and then we'll kind of take one by one.
Sure. They're all of equal importance. Sometimes people can't afford all of them at the same time. So I definitely think that the last will and testament is the most important document that people need to have. There are procedures if you don't have one, if someone passes away, but it streamlines the process, saves so much money for the families if you prepare a last will and testament. And that will direct where all of your assets will go, who will manage it, and who will handle all of your estate.
Okay, so let's talk about that, the estate. So what actually goes into a person's estate? Because I have a lot of clients that walk into my office, and I think they're maybe have some wrong interpretations of what an estate is. They say, oh, I don't have enough money to have an estate, or so what is actually in an estate?
So there's 2 parts of an estate. There's a probate estate and a non-probate estate. And a probate estate has anything that is in your name alone would hit your will and go via your will. So a personal property, a car, bank accounts that are in your name, those are probate estate assets. House, if it's jointly owned, then that would be a non-probate asset.
Gotcha.
So non-probate assets are things that are in joint names or have a beneficiary designation. Like life estate or any of those vehicles that you use for your clients.
So hypothetically, if a house is in joint name, like you said, it doesn't necessarily going to flow through the estate because if somebody passes away, the joint owner would take over that asset.
Correct.
Okay. So that's great. So that's the will, the last will and testament, so obviously very important. What would be the next document then?
I personally think the power of attorney is the most important because a lot of times I'll have people come to me and ask for a power of attorney, but they may be incapacitated or they may be too old to really understand what's happening, so you can't execute it. The point of a power of attorney is to grant someone the power to do everything that you can do. And that can have limitations if you wish. I usually make them broad so that one thing that you left out will be the one thing that you need.
Gotcha.
So the power of attorney grants that power to another person, and then if you do become incapacitated, that person that you appoint is your guardian. And to have a guardian appointed, there's a whole list of things that you have to do for the court, and again, it's thousands of dollars versus a couple hundred
getting the document
to get the document up front.
Gotcha. So what do you usually see that most used for? Is it writing checks for somebody who's incapacitated? Is it, going down and signing official documents for something? Where do you see most of that happening?
It's often arises because of a financial need, that someone needs to help a relative, a friend, someone dear to them manage their assets. It could also be, I always tell my clients, it doesn't have to be for a sad reason. It could be that you're in vacation in Tahiti and you need to do something or sell a house or you can't be at settlement, and you can have your agent sign for you because you've done this document.
Okay. I want to go one extra point into this because I know we've talked about this before, and I have worked with a lot of clients that are sending their kids away to college for the first time. And you brought this up to me, and I've never discussed it with anybody before until you brought it to my attention. But assigning power of attorney to the parents for the children that are going away to college. Can you explain that a little bit more?
Sure. When 18-year-olds go off to college, they are now adults. We may foot the bill for them, but they are still adults. So it's recommended to my clients that you have your children, if they're so amenable, to grant a power of attorney to you so that if something happens to them at school or you need information that they have this power. Otherwise, you won't be able to because they are
Technically,
legally
they're
an adult.
Right.
Yeah.
Yeah, that's a great idea. And again, something I never thought about until you brought it to my attention.
Sure.
So again, hopefully, like you said, the kids are willing to do that.
Absolutely,
Hopefully,
yeah.
again, if you're footing the bill, I think we have a pretty good pressure point there. So what would the third document be then that we're putting on that list of importance?
The third document is anytime you go into the hospital, they ask you, do you have a living will? It's also called an advance directive. This is the document that should something happen to you and you are unable to verbalize what you want, what kind of care, what kind of medication, or you have to make end-of-life decisions, this document delineates who is the person responsible for speaking on your behalf and delineates how you want your end-of-life decisions to be made.
So very important document.
Absolutely.
Yeah. So in all three of these cases, I think you alluded to it before, if you don't have them, unfortunately, there's something there for you
Yes.
that's already made up.
Yes.
So
There are processes.
it's obviously an extremely important thing to get these documents in order before something happens, whether good or bad, when you need
Correct.
them to make sure that it's done the way that you want it done.
Sure.
Who should have these estate documents? Because again, I have some clients that come in and say, well, I don't really have an estate, and I know we covered what's in it, and they say, I don't have enough money to have an estate, or some people don't know. Is there a dollar amount that you would say, or is it more broad-based that everybody should have it no matter what?
I personally think for the amount of money that it costs to get these documents that you should have them.
Okay.
It just streamlines things, and when someone passes away, people are very emotional. It's a very difficult time in people's lives. Sure. So having the paperwork handled and knowing what you're supposed to do alleviates some of that.
Okay.
There are some things that are called small estates that are easier to handle than larger estates. But again, it's good to have everything written down so that your wishes are carried out.
Sure. So dollar amount wise, that answers that. What about age wise? Do you recommend a certain age, or is it more of an actual maybe life event like a marriage or something like that?
I would say that, we talked about the 18-year-olds getting the power of attorney.
Sure.
I think that anyone who owns something in their own name.
Okay.
So a car, there will be ways to get rid of that if something happens, but it's best to have this document to direct where it goes.
Absolutely.
So I would say, a lot of people do it when they get married or when they have children in that age period.
Yeah. But even, like you said, the living will and the advance directives, once you're an adult, I would assume you'd want
Absolutely.
those decisions made by yourself and,
Right.
not somebody else. So I have a lot of clients that come in and ask me, Jake, I have a will that's 10 years old or a power of attorney that's 10 years old. How often do you recommend reviewing, redrafting? I know there's some new verbiage that comes out that should be added to wills. So what's your rule of thumb there?
Usually it's one easy thing for people to remember is any life events. So if you get married, if you do have a child, if you get divorced, you might want to look at it if you buy a new property, if you get an inheritance, if someone passes away, if your relationships change, because people will nominate guardians and maybe you haven't looked at that paperwork and that guardian is not the right person for your children anymore.
So any big life event or maybe even small life event, you at least want to review the documents. So let's say we don't have any life events really. Everything's status quo for a certain number of years. Any specific time frame that you really should look at, or?
There's nothing set in stone, but the life events is a good thing. And just every couple of years, pull out your documents. If you go on a vacation, just make sure that everything is as you would want it to be should something happen.
Yeah, okay, that makes sense. I get questions a lot about filling out wills and power of attorneys through online. Yeah. There's these, for lack of a better term, maybe a TurboTax type of law things.
Sure.
Can you explain that a little bit more and just tell me the pros and cons of going through something like that?
I'm not going to say that those aren't useful in certain situations.
Okay.
Like there are some people who have very little, or it's very straightforward, where they might just need this very, very simple document. I've had to redo some of them because because there's no one to talk to. So there's no one to say like, oh, well, Jake, what about this? And interact with and talk about, well, did you think about this? People just fill out the information and think they're done.
There's no one step deeper to ask a second question.
And I'm sure you have the same thing in your practice.
Absolutely.
Yeah. So there is a time and place for everything, but I personally recommend talking with an attorney so that you can have your specific situation addressed and, the people in your life fleshed out and the questions asked that pertain specifically to you.
That makes a lot of sense. I know, again, like you said, if it's a pretty straightforward case, that may be helpful. But if there are some moving parts and pieces, it helps to sit down with a human being and actually go over it. So we talked about the will a little bit earlier. What happens then if somebody does pass away without a will? Specifically, we'll talk about Pennsylvania since we're going to talk about our local community here.
Sure. So if you pass away with a will, that's called testate. And you go and you probate the will, and that process.
Go to the courthouse, hand in whatever you need to do, fill out whatever you need to do, and then go from there.
Absolutely.
Okay.
If you do not have a will, it's called, you pass away intestacy.
Okay.
And so you would have an administrator appointed.
Okay.
In that case, you need someone to raise their hand and say, I want to take on this burden.
Not a fun thing to do, I'm assuming.
No, it's not. This is a complicated process, and it is a responsibility.
Sure.
However, there are rules as to where your assets, where your estate goes if you do pass away without a will.
And who makes those rules?
There's a statute.
Okay, so it's
the government.
It's done by the government. So it could be the total opposite of theoretically what you would want to have your assets be
Absolutely,
done.
because even in like a friendly situation, maybe you have given money to a child for a house, a wedding, and you would have preferred more money to go to other children. It may be split equally.
Okay.
So if you want to direct stuff, you want to have an estate plan.
Yeah, I mean, absolutely. That seems like a no-brainer to have that set up beforehand if the government's going to tell me which way it's going to go. And I don't want to get too much into the specifics, but if we can just go with a married couple.
Sure.
So husband and wife, and neither of them have a will, and one of them passes away.
Sure.
Where are the first couple of dollars going? How does that get split?
And this is interesting for some people because in Pennsylvania you cannot disinherit a spouse, which is good.
Right.
But then there's rules as to the first $30,000, and again it gets more complicated if you have children. So the first $30,000 would go to a spouse, and that's called. You can also do an elective share. It gets into specifics, but there are rules as to how much goes to the spouse and then how much goes to children, and then it depends on if you have children of the surviving spouse versus children from another marriage. So,
and if you have no children but you still have parents living, part of it could go to parents.
Absolutely.
Is that correct? Yeah.
Absolutely.
So,
and that is something people do not realize. So
it's a wild roadmap.
They just assume that they're going to get what they and their spouse have created together, and they don't realize that maybe parents could take some as well.
Oh, well, that's definitely, again, I think a big proponent of getting a will done. Let's talk about taxes. So we talk about, husband and wife, whether they have kids, no kids, depending on who's inheriting what. What taxes have to be paid on a state level and on a federal level when somebody passes away?
Sure. In Pennsylvania, to husband and wife, it's a 0% tax rate.
Okay.
And then it goes 4.5 for children, and then it goes to 12 for siblings, and then 15 for general friends.
So if you like your neighbor Joe down the street,
that would be 15%.
That would be 15% of whatever that person has.
And then 0% again to charities.
Charities, yep. Okay.
And then with the federal rates, it's now $11 million and change per person. So to get a federal inheritance tax at this point, it's over $22 million for a couple.
So as long as you have under $22 million as a couple, you don't have to pay federal inheritance tax.
Currently, yes.
Okay, currently, yes. I know that's changed a few times over the last decade. It's gone up and down. So we will see where that sits at any point in time. But that just brings in another facet of why sitting down and getting your estate documents together and figuring out, I'm assuming, who you want as beneficiary and what money and how the inheritance tax gets paid, because that can get paid through the estate as well, correct?
Absolutely, yeah.
Okay. Do you see that more often, or do you see the individuals actually paying the inheritance tax when they get it?
I've seen it both ways because some people can, and it depends on how the will directs it as well. The will can say, I want all my debts paid, including taxes, off the top, and then the beneficiaries get it, and that way the beneficiaries don't have to worry about figuring that out and submitting it all. So
So both ways are perfectly fine. And again, it goes probably down to the wishes of, the person who's giving the money away.
Yes.
Yeah, well, that's good. I know we don't have enough time to dig into the weeds on a lot of this because I know it can get very hairy, especially because everybody has their own situation. But can we touch on trusts a little bit? So we talked about the wills, the power of attorneys. trusts, I know, kind of take it one step further, a
Yes.
little bit more detailed. So when do you usually work with trusts? And then, we can kind of dig in a little bit to that.
Sure. Something that is relatively standard for the documents that I draft is a testamentary trust for minors.
Okay.
Because you do not want to hand a 10-year-old a whole bag of money.
Gotcha. So what does that trust actually do then for a minor?
Sure. So what happens is it's a testamentary trust, meaning you draft the trust in the document and it doesn't exist during your lifetime.
Okay.
It springs from the document after you pass.
From the will?
Correct.
Okay.
And then it is funded from the minor's share.
Okay.
And when I say minor, I usually recommend that people push out the disbursement dates.
Okay.
Either forever, or you can pick, 25,
Right.
30.
So technically they're not a minor at 18, but
Correct.
in this document you could say, well, I don't want them to get it until 25, or every year they get a share until they're 30, or
Yes.
in theory, whatever you may want to do at that
Yes.
point.
And then
Okay.
that has many purposes, because it, encourages us all to find our own way and make a career. It protects if you have a marriage and it doesn't work out, because if your money's in trust,
It's yours.
that's a separate asset.
Right.
Yeah.
So that makes a lot of sense. So what about non-minors? So if we're taking minors out of the situation, where else do you see trusts being used?
They're the special needs trust, which is a whole different topic,
Yes.
which has rules and regulations. There's also, you can do trusts, I see quite often from mixed families. So if you have children from a first marriage and then you come into a second marriage and you want to make sure that everybody gets what you want them to get, you might utilize a trust in that case.
Absolutely. That makes a lot of sense. So I know you just alluded to it a little bit as well on marriages and what happens there. So prenuptial agreements. So do you work with them often? Or,
Yes.
I mean, that's obviously a big part of a lot of what we just discussed today, making sure if you want one, if you don't want one, what happens if you do and don't have them. Talk a little bit about that.
Sure. A lot of times you need to review someone's prenuptial agreement before you do their estate plan, or you have that conversation when they're doing their estate plan. Do you have a prenup? Because some people come to me before they get married as well, and post-nups.
Sure.
Because this is an easy way of figuring out how you want your assets to be divided if something happens. Hopefully it doesn't, but it's a good way to do when everybody's happy.
Absolutely.
As opposed to when they're not.
Right.
And this document can also explicitly say how you want your estate to pass.
So, in theory, will the prenup actually overrule the will? So if there is a prenup and the will's, say, written a different way, so say they did a prenup with another attorney and they never told you, you wrote the will the way they wanted to write it, how does that work? And I know that may be a little
That's a great
complicated question, but what happens with that?
Usually I have seen prenups say that the prenup can be overruled by the will.
Okay.
So you set up your prenup and you say everything's mine is mine. You have hands off of the inheritance, and you may waive your elective share, which is what you're entitled to because a spouse cannot be disinherited.
Right.
But it says if you draft a will and you give everything to your spouse, that overrides the prenuptial agreement.
Okay. So you can actually have those documents, or the verbiage written into that document to say it will override it.
Absolutely.
If it isn't, I'm assuming we're talking about legal cases that will probably go to court and get a little ugly.
Absolutely, yeah.
Okay. Last thing I really want to dig into today is I know you've worked a little bit with some charitable giving and clients in this area. I know there's a lot of charitable foundations and there's a lot of generous people in our community. So how do you help them with that in, as part of their estate?
Sure.
How does that fit?
Most of the time there's a lot of coordination between the university, the charity, because sometimes they want specific language. And you definitely have to have that language in the will so that it gets where you want it to go. The more specific you can be, the better. Whether you want it to go to a beautification fund or an education fund or anything that you can think of, I coordinate with the specific charity or the university or the foundation to get that language so that we put it into the document.
So instead of it going to a Villanova University and unrestricted where they can use it for anything, you can actually drill down and say, like you said, beautification or sports or the arts or whatever it may be under that umbrella.
And that would be a 0% tax too on those monies given. So it's, again, you're not wasting money. It's going directly to the charity of your choice.
Okay, and that's usually written under the will, or is there usually separate documents, or it's all
That's
done?
in the will. You would do a specific bequest to the charity of your choice.
Okay, yeah, that makes a lot of sense. Well, again, so we went through a lot today, but I want to just reiterate those three main documents again.
Sure.
What are the three main documents that if somebody is sitting there saying, okay, I either need to review my estate plan or start an estate plan, I haven't done it yet, 1, 2, and 3, not necessarily in order of importance, but what are those three documents again?
They are the last will and testament.
Okay.
And with that, you also want to check with your financial advisor or all your funds to make sure your beneficiaries are coordinated. For example, if you set up a minor trust and you want some of the 401k to go into that minor trust, you have to make sure that beneficiary designation
Right. So if
is
you have your
correct.
spouse on that, and
Yep.
you again write that you want it to go to the minor,
Yep.
that's not going to work because you have two different.
Absolutely.
things there.
And you have to check, the first beneficiary, the second beneficiary, and make sure it's written properly.
Right.
And the next one is the power of attorney,
Right.
which grants your agent the power to do what you can do, and it also is a guardian if you should become incapacitated.
Okay.
And the last one is the living will advance directive, which is your agent who is appointed if you can't make decisions for yourself medically and
Incapacitated
or
at some point, yeah.
delineates your end of life wishes.
Gotcha. Absolutely. Well, I appreciate all your time
Sure.
and sitting with us and talking through all these topics. I know they're not all easy to talk about,
They aren't.
but they are stuff that needs to be looked at and planned ahead of
Absolutely.
time, because if we get into a situation and you don't have these documents, it can go bad fast.
Yes.
If our viewers have other questions, is it okay if they reach out to you?
Absolutely.
Great. We will definitely put your information up on our screen.
Thank you for having me.
Thanks, Laura. Thank you again. This has been Jake Szulinski with Investing Sense, and we will see you next time where we will be talking about Medicare. Thank you, and have a good day.